rise.
Good morning. Thank you. Please be seated. Good morning. The case for oral argument today is a very lengthy caption. I'll simply reference the name of Tibbs versus 3M et al. The first order of business is to acknowledge and recognize that Justice Verdon is not sitting on this case. And in her stead, we're so pleased to have one of South Carolina's outstanding circuit court judges, Judge Courtney Clyburn Pope from the Second Circuit. And Judge Clyburn Pope, thank you, ma'am, for being with us today. We appreciate it.
Thank you for having me.
I've been given a list of how council is going to break the time. Y'all might need to help keep us on track to make sure we follow it, because everyone's dividing up their respective arguments. And I understand, Mr. Carroll, you're going to do the first 15 minutes for Altred? Yes. All right. Whenever you're ready to proceed, sir.
Thank you, Chief Justice, and may it please the court. My name is Todd Carroll. I'm here on behalf of the Altrad appellants. Your Honors, I anticipate that we'll have a lot of issues that we talk about today. The briefs are extensive, as you know. But as we go through the day, there are 3 points that I want to make here at the outset that I don't want us to lose sight of. Number one, Cape Intermediate Holdings Limited is not even a party to this case. We're going to talk a lot about them today, but they're not a party to this case. Number two, Cape Intermediate Holdings has not been served with anything in this case. And number three, Cape Intermediate Holdings has no property in the state of South Carolina. No matter what else we talk about today, these 3 points are undisputed, and they're unrefuted in the briefing, and they're unrefutable. This is just the reality of the case. We're going to be arguing about CIHL, but it's not even a party to this case. And that's a critical fact to numerous of the arguments that are contained in our briefs. And respectfully, with that, I welcome your questions. There's no jurisdiction below. This receivership is a nullity. It is a nullity from the Park case. It's a nullity from the Tibbs case.
How is it a nullity from the Park case?
Well, for a variety of reasons. Number one, CIHL was not served with anything in the Park case. It's not even a named defendant in Tibbs, the case that we're on here today. But in Park, it was named as a defendant, but then it wasn't actually served with an operative complaint.
What is the operative complaint?
The operative
What does that
complaint,
mean? I don't understand that term.
the complaint that a defendant is expected to answer.
Okay,
The
so
complaint that governs the claims that are pending at that time.
didn't Judge Toll find that they were served with the First Amendment complaint?
Yes, Justice Hill,
Okay.
she said that.
So
but-
why wouldn't that be the operative complaint as far as they're concerned?
Well, two points on that. Number one, that's a jurisdictional fact. So her statement about that is not due anyway. This court reviews that de novo. And there is nothing in the record that actually does support it. It's just a statement of her honor that has no basis in the record.
What statement are you talking about?
The statement that CIHL was served with any complaint.
Well, she made findings of fact about that. I don't understand where you're coming from with that.
Well, she made a statement that it happened, but if you look at the actual record, if you look at the process server's statement, there is a affidavit of a process server
I understand all that, and there's some debate about what kind of stamps were necessary in the United Kingdom. We don't need to get into that. My question is, that could be the operative complaint, and as far as the case stands now, that is the operative complaint for that defendant, correct?
No, sir. At the time of that, at the time the process server says he sent a summons, he doesn't mention a
I
complaint.
understand all that, but she's already found as a fact and under the law that they were properly served. And that's also an interlocutory matter, isn't it?
Well, Your Honor, it goes to the heart of this issue that's on appeal. And again, it's a jurisdictional fact. Those are reviewed de novo by this court. And again, I certainly acknowledge that Justice Toll said that a complaint was served. But I also contend that she's the only one that said that. The actual process server didn't
Well,
say that.
She may be the only one that matters at this stage, so.
I disagree. I've reminded you of what I believe the standard of review is. But as to the functionality, let's assume that the first amended complaint was indeed in that package. Let's assume
Okay.
that is true. The plaintiffs, with Judge Toll's permission, filed a second amended complaint before any responsive pleading was due to the first amended complaint. As a matter of law, that superseding complaint moots the first amended complaint. Let's say
Okay,
CIHL, I apologize.
The second, when a party files an amended pleading that doesn't get served, then the whole case is over because it never got served. Is that your position? Because that's the logical end of your argument.
That would be my position as to that defendant, yes.
Okay.
If a defendant is served with a initial complaint and then there's an amended complaint, the plaintiff doesn't have to go through the whole service of process. They have to serve it on them, but they just mail it to them.
Correct. Yes,
There
sir.
doesn't have to be proper service the second time.
Well, there doesn't have to be service of process again, but there has to be service. And there's nothing in the record that suggests that ever happened either.
What is your understanding of what the receiver is after as to your client? Not as to Cape, as to your clients.
That's a great question, Justice Few. My understanding of what the receiver wants is he wants to take every asset he can find of Cape Intermediate Holdings and bring them all to South Carolina, and then set up a process where plaintiffs can come to him and he can pay claims in the name of CIHL. And as far as what he wants from my client,
So is your client CIHL?
it is not.
Well, you just said my client, and then you said CIHL.
No, I'm trying to get to, respectfully, Justice James, I'm trying to get to what I think he wants from my client.
And I apologize interrupting you answering Justice Few's question.
No, look, that's an excellent distinguishing point. We've made it in our papers, and I don't want there to be confusion here today. What I understand the receiver is claiming to do is to sit in the seat of CIHL and say, give me all of your assets, and then say to Mr. Rawls' client and to my client, hey, you owe me billions of dollars. I'm CIHL, you owe me billions of dollars. Give me billions of dollars, and then I'll bring them to South Carolina and I'll pay claims from unknown future potential tort plaintiffs. Look, it sounds bizarre. It's a hard question to answer, but I think that's how the pleadings read.
As to your client, is it true that none of those assets are located in or legally attached to South Carolina?
That's correct. CIHL has no assets in South Carolina. My clients have no contacts with South Carolina. I've seen in some of the papers, well, there's a subsidiary of a subsidiary of a subsidiary of a subsidiary that has an office in like Williamston or Williston, South Carolina. That's not my client. That entity is not a party to this case.
Well, why wouldn't the insurance assets be located here?
There are no insurance assets, and the receivers made that clear to the circuit court. Like, I understand Welch was about insurance assets. That's not in play in this case.
All right, well then what about the lawsuits, or if you want to refer to them as choses in action, whatever that means?
Oh,
Are they Where are they located?
They're not located here. If there is such a thing, which I know your honors are aware, it's one of the points that's on the court's notice to the public about the issues in play. There's been a release between my clients and CIHL as to the so-called chosen action. But if they
Well, let
exist
me stop you
anywhere,
right there. How can a company that is under a receivership enter a release about, as to claims that the receiver is bringing? Tell me how that works.
So Justice Hill, I want to answer your question, but I want to make, the way you phrased your question drives home a key point of this entire scenario. There is, under Title 15 of the state code, there's no way a receiver can be put over a company. That's just not contemplated by Title 15. It is contemplated by Title 33. We've put this in our papers. It's contemplated by Title 33, but that could only apply to a domestic South Carolina-based corporation.
Well,
Under Title 15.
You said that in your brief. You said you cannot, a foreign corporation cannot be in receivership in South Carolina,
That's right.
but you didn't cite anything to support that. There's no case or statute you cited to support that. So I don't see how you can make that broad of a statement, especially in light of subsection 5 of 156510.
So, Your Honor, I believe we cited Title 33's provisions, 33, 18, 13, 320 talks about receiverships and custodianships for judicially dissolved South Carolina corporations. And then 31, one of the definition of corporation, I'm blanking on the actual section, but it's the definition of corporation says not a foreign corporation. So that is 100% part of the statute. But Section 5, the catch-all, says that the receivership statute works in the form that it was allowed to work under case law prior to the statute,
Right.
except as otherwise provided by this code. I mean, there's a phrase at the end of Section 5 that limits. Section 5 is not does not allow a court to appoint a receiver to become a roving lion who can walk around devouring assets wherever he or she finds them. Section 5, by definition, is limited to everything else that's in the code. And as Your Honor knows, Section 4, the section immediately above it, limits the domain of a receivership involving foreign companies to assets in South Carolina. That's a function of the state code, but it's also a function of the U.S. Constitution. And this is the whole extraterritoriality point. It's Article 4 of the U.S. Constitution, as well as Congress's Commerce Clause powers. I know we were filing briefs in this situation up to 2 days ago. Mr. Ashmore's brief really brought that point to a head. A federal receiver has extraterritorial jurisdiction. A federal receiver can move among the various districts of the U.S. court, the U.S. District Court. A state receiver cannot have that same authority.
So Welch was incorrectly decided
Well,
because it clearly allowed the receiver to seize assets beyond the territorial jurisdiction of the state of South Carolina.
well, Chief Justice, it did, but it was talking about the insurance asset, which is at the same time nowhere and everywhere. I mean, Welch was very fact
You say
specific.
that's not what we're talking about here.
That's definitely not what we're talking about here. Look, I would respectfully submit that Title 15, a receivership under Title 15 is limited to actual property, a tangible thing. I understand Your Honor asked about a chosen action. Chief Justice Fuse, and you reacted to that phrase. Your concurring opinion in that case walks the South Carolina bar through the history of that phrase. And one of the very first times you identify is a 1891 expression of the phrase chosen action, where Your Honor's concurrence points out that at the time our receivership law came into effect, a chosen action talked about the right to recover a physical thing. Insurance, I think, is different, but I think Welch was all about insurance. I mean, there was a whole exchange with counsel for the receiver at that oral argument about, hey, what's this I hear about a receiver being allowed to run a Canadian company, and the answer was, no, 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 we're here for the insurance. There's no insurance in this case. Welch is fundamentally distinguishable on that point when it comes to the actual asset that was in play there.
Who has confirmed from Cape that there is no insurance?
Well, I believe the receiver has, but at, it would also make no sense for Cape to have insurance anyway. It was not in the United States. Everything that it did that would have been in play with insurance was back in the 50s, 60s, and 70s. And we know that NAC did respond. NAC had insurance. NAC responded to complaints. NAC responded to claims. NAC paid them. But as far as Cape's actual insurance, I believe the receiver has made that representation of the
The
circuit.
question would be whether your client has insurance that would provide indemnity to Cape, right? I mean, for our purposes here, the receiver is after you to get a hold of assets that can be used to pay judgments. You say there's no insurance, but if your client had an insurance policy that somehow provided that it would indemnify Cape, that would be, if it exists, that's, I mean, I don't want to rewrite Justice James's question, but that's the point here, it seems to me, as to whether there's any insurance at issue. Because, I mean, we're not talking about, in this thing we're talking about here, we're not talking about Cape. We're talking about you, your client.
Yes, sir.
And the receiver in this context is not trying to deal with assets that Cape has under its name. I think he's trying to deal with assets that Cape has in your name, right? Through this amalgamation theory?
Justice Few, perhaps that's never been articulated below. What you've just said.
Well, that's why I asked you in the beginning what they're after, and I, obviously look forward to hearing their own answer, what they're after.
But let me, just like I tried to unpack part of Justice Hill's question. I want to unpack kind of the structure of your question. The receiver, this receiver is a nullity as a matter of law, all the way back to Park. He doesn't exist in the eyes of the law because, again, you can't appoint a receiver over a foreign company under our state statutes. So this idea that this, and CIHL wasn't served in Park. The Park appointment order was about Cape PLC. But our position is best summarized by the table of contents in our gray brief. We believe there are 13 individual independent reasons why this whole case should be vacated. And we think we have a clean sweep on all 13, but I know they have to have a clean sweep on all 13 for this case to continue. But the way you phrased your question was assumed that he had the authority to speak for Cape and go out into the world and try to find additional insurance. He can't speak for Cape. He can't speak for CIHL.
For purposes of my question, though, it was fair to make the assumption that he can, because otherwise, you're right, we're not even here.
Yes, sir. No, I understand, but I didn't want to tacitly accept the assumption. Your Honor, I see I've got the red light.
This, what Justice Few is talking about, this right of CIHL or whatever you want to call them, to go after your client, whatever that right is, it's a right of that corporation, correct?
Yes, sir.
Okay.
And you
All
asked
right,
me
now wait,
where it is.
Hold on one second. Where does that right reside?
It
Is
resides in Europe.
England or
It
France or here or?
Well, I know it doesn't reside here. It would reside in England, where CIHL is located, or in France, where my clients are located. And CIHL has released my clients from whatever this cause of action could be. And in turn, my clients released CIHL, but not just for this case. The circuit court didn't give a direct answer on this. It just kind of disregarded this release, but this is an important thing. My client acquired controlling interest in Cape Intermediate Holdings in 2017 through a public tender offer. We bought public shares of the stock of this company. If my client were to sell those same shares tomorrow, it could not sue Cape Intermediate Holdings for whatever that company may or may not have done in the United States
Because of the release.
because of the release. It's
All right,
not
well,
limited
that
to
goes
this
back-
case.
I'm sorry, that goes back to my earlier question, which I think I may have distracted you from answering. How, and I know you're going to say perhaps that the receivership is void, nullity, but assuming it's valid, let's just assume that.
That's a big assumption, but
Okay.
I'll play
I'm-
along.
I'm incorporating all 47 of your objections to it. But
We may have had
assuming
more,
it's,
but
assuming
okay.
it's valid, how can a corporation that's under receivership release claims after the receiver's been appointed? Otherwise, why have a receivership?
Well, okay, so a claim in the abstract is not something that a receiver can actually take a hold of. He can take, the case law talks about debts. It doesn't talk about undefined claims in the future. It
Well,
talks
then why
about
does
actual
Rule
debts.
66 say that the receiver can sue? I don't
In the name,
understand.
it says he can sue
Yeah.
in the name of the debtor, not defendant.
I understand that. That's not persuasive to me, but I understand that's your argument.
Well,
But go ahead and answer the question. Let's just assume that he can sue or she can sue. And how can you release claims once a receiver has been put in place for that company? And the receivership order covers marshaling the assets.
so if I'm understanding the question, how can a company in England release a company in France for a claim that it may or may not have? Because a circuit court in South Carolina has appointed a attorney in South Carolina
Mhm.
with no notice to the English company.
I understand
I-
all your, I'm gonna set, assume it's valid. Assume it's valid.
Assume the appointment is valid. And that
Yes.
every asset of Cape Intermediate, wherever it is in the world, is under the auspices of this receiver.
Yes,
It's
yes, just indulge me, indulge me.
How can that company, because the Welch case says that the receiver has to stay out of the boardroom, and a decision to sue or not sue is exclusively within the purview of that company's board of directors, irrespective of the receiver.
What's your authority for that?
The Welch decision.
No,
It's-
no, for a right to sue is a decision of the corporation's board of directors and not the receiver.
Well, I believe we cited authority in our brief, but I know that as a matter of just the corporate law of this state, our Title 33 says that a board of directors is who controls the decision to sue, the decision to defend, the decision to enter into a contract.
That's
Those are-
true under ordinary circumstances, but doesn't the appointment of receiver, assuming it's valid, change that dynamic in the analysis?
I don't believe it does, and this court's Welch decision says that. And I'll go one step further. There's a case from the mid-1930s. Arcadia Mills is the defendant. And this court, in its opinion, said, hey, the circuit court has appointed a receiver who is running the mill. You can't do that. Receivers can't operate a company. Same concept that this court announced or reiterated in the Welch decision. Receivers can't operate a company. Now the court authorized the receiver to sell the business as a going concern because it was a South Carolina company, and that was what I would now say would be a Title 33 receivership. But the point remains. It was the law 100 years ago, and it was the law again in Welch. A receiver can't make corporate decisions and sue, defend, make contracts. Those are decisions of a corporate board.
All right. Thank you so much.
Thank you, Your
sir.
Honor.
Mr. Rawl, I believe you've agreed to 5 minutes. Is that correct?
Yes, Your Honor.
Good morning, sir.
Good morning. May it please the court. I represent the charter appellants, which include two UK companies, and one U.S. company. The two U.K. companies have no contacts with the United States and have never manufactured, sold asbestos products. My U.S. client, ESAB Corporation, is an entity that was formed in 2022 and has also never manufactured or sold asbestos products. My clients were sued in South Carolina, by what we claim is a Title 15 prejudgment receiver that was void at the time that he was appointed. And what I would like to focus on, Your Honors, is the purpose of a prejudgment receiver. And this law is, a couple hundred years old, and as this court has explained, there are lots of different types of receivers. First of all, post-judgment receivers, as this court has said, is commonly made amongst almost as a matter of course where it appears that the judgment debtor has property which ought to be applied to the satisfaction of the judgment. That was a 1984 case by this court. But unlike post-judgment receiver appointments, pre-judgment receiver appointments face the highest burden, requiring extraordinary circumstances as reinforced by this court's ruling. But the sole purpose, as repeated by almost every single Supreme Court decision in history about pre-judgment receivers or receivers pendent light or pendente lite.
Are you sure that's pronounced?
I am not sure.
Is that Latin? Because Justice Hill doesn't like Latin.
I struggle with it myself. But the sole purpose of a prejudgment receiver is to hold and preserve specifically identified assets of a defendant in a case, assets that are at risk of dissipation or loss in the case pending the judgment in that case. We cite, I think, a dozen prior Supreme Court cases stating that. And what I'd like to focus on, real quick, and I put in our briefs, I think, a list of 15 prerequisites, that are set forth either by the Supreme Court opinions or for this point today in Title 15 of the mandatory prerequisites to the appointment of a prejudgment receiver or any receiver in South Carolina whatsoever prior to final judgment in a case. And as this court explained, the taking of property from the hands of owners and placing it in the hands of a prejudgment receiver has always been regarded by the courts as a severe provisional remedy to apply with great caution. And importantly, this court explained shortly after the adoption of the receivership statutes in 1870 that a prejudgment receiver is an indifferent person between the parties to a cause appointed by the court to receive and preserve the property in the litigation pending judgment in that litigation. Again, there are several conditions precedent to the appointment of the receiver. They're listed in my brief. I only want to focus on a few of them today. Primarily, I'd like to focus on Title 15, 15, 65, 50, and 60. And those deal with the bond provisions or the protections given to people whose property is sought to be put into the hands of a prejudgment receiver.
Are you gonna, is your client gonna post the bond? You gonna offer the bond?
Your Honor, while the receiver is seeking property, that is in the hands of my client, the appointment order, one, with regard to the case we're in now, which is the Tibbs case, frankly, there is no appointment order. But any order that is in the Tibbs case, none of them have the mandatory property valuation required to allow my client to pay a bond.
So your client would be willing to put the bond up in the Park case?
I don't know that,
You don't
well,
know?
my client is not a party to the Park case.
I understand that, but you're making arguments attacking everything that happened in it, so. I
I'm
guess-
saying, you know, in general, these are the conditions precedent for the appointment of a prejudgment receiver.
I understand, but tell me how you get around the ex parte Rowley case that says a third party can't attack collaterally the failure of the receivership order to impose a bond.
First of all, you know, that case is dealt with an insurance matter and it was a trustee issue where the allegations in that case were that the reserves of the insurance company were at risk. So all of that case right now would be brought under the specific insurance statutes, not under Title 15, but the specific insurance statutes that allow a receiver to be put over an insurance company.
Well, it was
You know-
interpreting the exact language we're here about today,
You know,
correct?
and what that case said is that, you know, the person, the shareholder of the insurance company, you know, did not have standing to make the argument because they were not in the possession of the property that the receiver was seeking to put into his possession.
Right.
In this case, Your Honor, the receiver is suing my client, you know, for what they claim to be billions of dollars to put in their possession. So my client absolutely has standing under the statute because the receiver is after the assets in the hands of my property.
Okay.
You know, but regardless of what that case says, this court, you know, I would point to the specific language that the legislature put into Title 55. Excuse me, Title 15. The first, you know, which is, you know, 1565-50, the title of that provision is no receiver shall be appointed before judgment when bond is offered. You know, this is not just, you know, certain types of receivership. Title 15 is clear.
Well,
Before this court
who
can-
has offered it? Who has offered it?
You know, that is what the Truesdale court made very clear, is that it's the condition precedent to even appointing a prejudgment receiver is the specific identification and valuation of the property to be put into the hands of a receiver. And of course, that makes perfect sense because the whole point of a prejudgment receiver in the first place is, hey, there's property in the hands of this defendant that is being dissipated, you know, is at risk. We need to take that property out of the hands of that defendant before it is gone and put it into the hands of a prejudgment receiver. You know, here, you know, there's never been any identification of property. Why? There's never been allegation that any property is being dissipated. You know, if there's specific property whether accounts or property being dissipated, that's the purpose of a prejudgment receiver, is that the plaintiff, if you will, can say, this property is being dissipated, you know, either under, you know, 1565-10-1, which is the section that specifically talks about prejudgment receivers, where it says that if the asset is the subject of the litigation and it is at risk, then it can be put into the hands of a prejudgment receiver. The other two, sections 4 and 5, you know, as this court stated in Welch, and as numerous other courts have said, there has to be some kind of equitable wrongdoing before, you know, showing that there's a risk of dissipation prior to the appointment of a prejudgment receiver. And so,
Mr. Raw, I'd like to ask you a question to educate me, help me understand and untangle this Gordian knot. I want to start with the foundational question, then I want to immediately segue to the bond issue. The fine arguments that are included in the briefs that you gentlemen make today, were these arguments fully developed in good faith before the trial court?
we have been making the arguments with regard to the lack of the valuation provision since the very first briefing
Okay,
on
you-
the dissolution of.
I'm not sure what that means. I hear these good arguments. I read good arguments. Then I open the brief to try to get ready for this hearing, and all I see is a Sergeant Schultz defense. I know nothing. I see nothing. I will not cooperate. And for example, the statement made that our company never did any business in South Carolina. Well, it seems like you would want to rush forward and engage in discovery to prove that you have a defense that would be dispositive in your favor. So I hear these good arguments, and y'all are so capable and so smart, but when I read the record, I don't see all this stuff fully developed. I see sort of a roadblock put in front of the trial court of lack of cooperation of moving the ball forward. If you want to respond to that, you can, sir.
Yeah, I'd very much like to, Your Honor. So,
And then I'll ask you the question about the bond.
thank you, Your Honor. So, the arguments that I'm making today, were made at the time that my client made a motion to dismiss for lack of personal jurisdiction. And then we also made other arguments, assuming that we lost that, if we would lose that argument. And then at that court, of course, the Justice Toll said we may proceed without risk of waiver on a personal jurisdiction argument. So we made also our motion to dissolve the receiver. And we set forth all the errors, all the lack of personal jurisdiction, the bond issue, all of those arguments were made back in the last quarter of 2023. Justice Toll issued an order that both modified the park appointment order, allowing the receiver to act on behalf of additional people, allowing him to act in a case other than park. And that same order also denied our client's motion to dismiss for lack of personal jurisdiction. Both the charter appellants and the Altrat appellants appealed that order in December of 2023. That appeal, which dealt with,
I'm not asking you, I don't want to hear about appeals.
No.
Because y'all have appealed so many interlocutory orders, it's unbelievable.
if I may, I just want
Just
to tell
make
you
it
why we
briefly.
did not.
I'm not
do more.
interested in the appeals. I asked you about the conduct in the trial court, and I want you to limit your response to that, sir.
Yes. In the trial court, at every step, we challenged the jurisdiction of the trial court to move forward. We stated that because the issues were with the appellate courts, for just that appeal from December of 2023 until June 26th of 2025, the circuit court repeatedly forced our clients to come back to the court, and we said, and every time, there's no personal jurisdiction over us. Our personal jurisdiction and appeal is pending with the court, has not been decided, and that same appeal has the primary issue is whether this receiver was void ab initio and has any authority to act whatsoever. And so, at every step, we stated why the receiver was void. We stated why the court had no subject matter jurisdiction. We stated why the court did not have personal jurisdiction over our clients. So, Your Honor, the underlying record, we did not engage in discovery. We objected to the jurisdiction of the court at every stage because, and then, of course, our original appeal culminated in the June 26, 2025 order, where this court picked up the arguments we were making and said, how can this receiver appointed in one case act in another case, and gave the mandate to the circuit court to say, the a receiver may not act in a court in which he was not appointed. And so, from the way I look at it, Your Honor, this court picked up these prerequisites in Title 15 in the specific limitations.
Permit me to please continue, sir.
Yes, sir.
I want to ask specifically about the bond issue. And you make a very valid point. I mean, the statute 156560 says when you appoint the receiver, there shall be inserted, the word shall. So you make a valid point, and it may carry the day for you, and we want to hear from the other side about how they get around the statute. But it's not as easy as it may ostensibly appear. How is the court to know when there's no disclosure, there's no discovery, there's no identification of property, everything's hide the ball, yet somehow the judge or the receiver's got to be clairvoyant to come up with an amount for the bond to satisfy the mandatory nature of the statute for this requirement. And we don't want to interpret a statute that rewards misconduct. So how do we deal with that? On the surface, you've got a very strong argument on the statute. But how is anybody to know what the value of the property is in order to set a bond when there's no cooperation or disclosure?
It's an excellent question, Your Honor. It goes back to the actual purpose of a prejudgment receiver. In none of these cases is there a judgment against any CAPE entity.
We understand that.
Right? So, in order for a prejudgment receiver to be appointed, it's not because, hey, we think you're a bad company. Hey, we can't get personal jurisdiction over you. And we know, based on decades of UK law, that it's likely that the CAPE entity will not respond to a complaint in the US, which is why, by the way, no plaintiff's lawyers in the US have sued CAPE for 30 years.
That's a fine statement.
Right.
It has absolutely nothing to do with my question.
I apologize. I will get to the
I'm
point then.
asking, how do we interpret the statute to give it effect in these circumstances? It's mandatory, yet how is a receiver who's an arm of the court, appointed by the court, how do they determine what the assets are, what the value is in order to set the bond so they can comply with the statute?
Thank you, Your Honor. So that information should be in the motion to appoint a prejudgment receiver that is made by the plaintiff in the underlying case. That is not something to be determined. The Truesdale Court made it very clear, not something to be determined after appointment, it has to be determined before appointment. So,
All right, so could a plaintiff say, based on moral fraud, et cetera, and that's in dispute, but we think we've established it, we want to be a receiver appointed pre-judgment. As a part of that court, we want to comply with the statutory mandate. So we're asking for some cooperation from the other side in order to know what the assets are so a proper bond can be established. Would that be an appropriate mechanism to comply with the statute?
No, Your Honor. What the statute requires, and it is that the identification of the specific property that the plaintiff, if you will, is alleging is at risk of dissipation, and therefore should be taken out of the hands of the defendant and put into the hands of the prejudgment receiver for the purpose of holding and preserving that property pending judgment in that case. The purpose of a receiver is not to appoint it over a case and to let him go and try to amass as much money as possible by suing anybody they can sue. The statute presupposes the specific identification of the property in the hands of the defendant that is being dissipated. That's the wrongful act here. They're fraudulently dissipating the assets. And
So
it-
you're
it-
saying that it's rare to have a pre-judgment receiver.
very,
We understand. And you're saying the onus is on the other side to identify the property on the front end.
100%, Your Honor.
They
The-
can't go in the dark and say, we want to go on a searching expedition just to see if there's something there. So they have to identify it. And if they identify it, then we know the value.
Exactly. They must.
That's your point.
They would say, this is specific property that is at risk. This is identified, we're making this motion, to the court to appoint a pre-judgment receiver because of this risk. We're asking the court, because of all this moral fraud, to take this asset out of the specific asset out of the hands of the defendant, put it into the hands of a pre-judgment receiver to hold that asset so it is no longer at risk.
In your
Pending- pending-
judgment, what is the asset?
That is the biggest problem of this case.
Isn't
There
it
is no asset.
isn't it the claim against this side of the courtroom?
So,
The third party claim?
if I would say that the receiver filed and I'm going to put in air
Yes or
quotes,
no? Yes or no?
it cannot be. What the receiver says is it is the cause of
The
action for
receiver-
unjust enrichment, which
the-
I do not believe that can be the case.
The receiver says that it is impossible to ascertain the value of choses in action for the purpose of posting a bond.
Your Honor, I 100%.
Is that true or false?
It is impossible because it is not the purpose of a prejudgment receiver. The statute does not allow you to value some unknown property. And that's what the receiver is asking. What they say is, we want everything, right? We don't.
Well, I'm really anxious to hear what they say they want because I've not read everything anywhere.
I apologize. I think it says billions of dollars.
I want to weigh in on this bond thing. I don't hear you as making the argument that Justice Toll's order should be reversed because there's no bond. I hear you saying it is in fact, as Chief Justice just asked you, it is in fact impossible to set a bond here. That's your point. You're not running from that. That's your point. And you're using that point to illustrate your overarching argument that this statute simply cannot apply to the situation to which it has been applied. Now, am I wrong about that?
Yes, sir, Your Honor. My point is that the statute applies to any and every attempt to appoint a pre-judgment receiver or a receiver before judgment in a case. It applies.
Well,
To everyone.
You make this big deal about the fact there's being no bond, but you acknowledge there's no way to calculate a bond on this record. Isn't that right?
I would say that, Your Honor, because no property has been identified, it can't be.
I got
evaluated.
that. And I think that this is the reason we're not hearing what you're saying, because you're asked a question and you're jumping ahead to the point you want to make. You're not really answering this question that is, and I get why, I'm not faulting you for it, but we're hung up on this, or I am, and I think the others are too, hung up on this bond thing. What's the significance of it? As I look at the situation, the receiver himself acknowledges that it is impossible where he stands to identify an asset. Now, he's got reasons to explain that, which is the misconduct of CAPE and perhaps your client. But so I think the receiver himself acknowledges there's no way to have a bond here. I frankly don't understand why we spend all this time talking about a bond.
So if I may break,
Cannot be a bond when there's no asset. It's not possible.
I agree. There cannot be a bond when there's no asset, but with no identified asset, there can't be a pre-judgment
You
receiver.
just jumped ahead. So you're not, if it's impossible to have a bond in this situation, then it is counterintuitive for you to argue that we should reverse Justice Toll's order on the simple point that there's no bond.
Your Honor, my argument is that because the statute mandates the valuation provision, And this court has stated that if that provision is not in the appointment order, then that order is void. So yes, I'm asking that this court reverse.
That's kind of what I said when I started this whole dialogue.
I apologize if I misunderstood. But I
Aren't
think
you,
it is-
aren't you really saying that a prejudgment receiver can only be appointed when the subject matter of the action is physical, tangible property, like a cotton crop or something? Isn't that the scope and end of your argument?
That is, most of the cases talk about physical property. But whatever the property is, whether it's physical, whether it's an account, it's not up to the receiver to identify that property. I mean, this is not a question the receiver, by the time he's acting, he's already been appointed by some order. So this is not the receiver's duty to identify the property or to identify, why the order that appoints him is, void. It's up to the party who made the original motion to appoint a prejudgment receiver to identify in that motion, here is the property, whatever they claim the property is, whatever they claim is at risk in the case prior to the judgment, that has to be identified in the motion such that that property is the burden of the moving party to show why this high burden can be met. And, if there is no property identified, and Truesdale makes this point better than I can, if there is no identification of property, there's no property to be valued, and therefore it is an improper prejudgment receiver request. At that point, it's just a request or a motion. That motion should have been denied because there is no identified property. The statute, our legislature protects all of those people who have assets by saying, if the court goes forward and enters a appointment order to appoint a prejudgment receiver, it must, in every order, every time, include the valuation provision. Why? That is the due process protections given to, the parties whose property is being taken. There's no contract saying a value. I mean, there's no judgment here. This is just taking the property of a defendant and putting it in the hands of somebody else before there's any liability or damages to determine. So that you're right. The answer, I think, Justice Few, I think it was your question. 100%. If there is any appointment order without the valuation provision, it is void, and it does not give the receiver, any ability to act.
Thank you, sir. I think we'll hear both from you, Mr. Roll, and Mr. Carroll in reply.
Thank you very much for your time.
Thank you, sir. And Ms. McVeigh, I think I have you for 8 minutes for Tibbs. Is that right?
Yes, sir.
All right. Good morning, ma'am.
Good morning. Thank you. May it please the court. Just by way of direction, I'm going to address the moral fraud of CAPE, the motion to appoint the receiver, any questions you have about the Park Estate or the service of process. Mr. Lay is going to address any questions about Adams, the scope of the receivership, the waiver issues, and the release, if that kind of gives a roadmap for how we're going to argue this today. The purpose of a receiver under Section 5 is to prevent ongoing moral fraud. And it really is undisputed that CAPE's conduct in this case has been reprehensible. We know that they were responsible for 90% of the blue and brown asbestos sold into the United States and directly into South Carolina. We know that they were the primary manufacturer and seller to the most dominant asbestos manufacturers in the United States, including Pittsburgh Corning and others. We know that they sold directly into South Carolina, and that's in the record in front of you.
Why didn't you sue the appellants?
So because we didn't know what was out there with CAPE, and I can get there in just a moment if you'll allow me. But at the time when, and if you'll permit me just to walk through the moral fraud and kind of tell you why we made the
All right,
motion.
I withdraw the question.
You don't have to, and it's a fair question. It's a fair question. It's undisputed in this case that Cape had knowledge of the disease, the horrors that it caused on workers and even people living around. We know that they threatened to ruin medical doctors. The list goes on and on about Cape's bad conduct. And if Cape were to appear in South Carolina where there is personal jurisdiction over them, we believe that there would be verdicts and perhaps punitive findings against them. But that's not the reason that a receiver was appointed in this case. The reason that a receiver was appointed in this case is because of Cape's historical scheme to avoid U.S. liability while continuing to sell their lethal product into South Carolina. How do we know that? Well, they wrote it all down. These are Cape documents where they wrote down what they were going to do. As this court saw from the record, they participated in exactly one lawsuit in Texas. And after that, in 1977, Cape wrote down, having heard more disturbing information recently about the value of Texas awards, we are rapidly coming to the conclusion that Cape should take a risk on the UK enforceability and withdraw. In practice, we cannot foresee any court or government enforcing a judgment which would have enormous financial repercussions. And then they said this, we really cannot be said to have a moral responsibility, and we are simply victims of the U.S. product liability cult. So how did they accomplish their scheme? That's what they wrote down. It's going to be too expensive for us. So they did it in several phases. Step one, in the 1970s, they just said, we are no longer appearing in U.S. courts. Despite selling 90% of the amosite and crystallite asbestos into the United States, we're just not going to appear anymore. They allowed default judgments to be entered against it, and they relied on the UK courts to refuse to enforce those default judgments. And this was written down. It was calculated. Why? We have legal opinions in the record that said default judgments cannot be collected. Cape thumbed its nose at the US courts, the law, and the victims. Step one. Step two, Cape has to liquidate NAC, its domestic arm, and they did that. They dissolved NAC to prevent jurisdiction, to prevent any kind of attachable asset, and then they went to step three. Cape said, we're making money selling asbestos in the United States. We want to keep doing that, but we don't want to be subject to the US courts, so we're going to set up this shell company. And with the shell company, it's 100% owned by Cape. It had the same US customers as NAC. It had the same employees as NAC. It had the same pension plan as NAC. It was the same office building. That was step three. And the result of that was that this elaborate scheme paid off for decades, and they didn't pay any US victims of their scheme. US plaintiffs who ended up getting default judgments, like the Adams Court, found it unenforceable. Thousands never pursued Cape at all because they knew they could not collect.
I think I know the answer, but I want it on the record.
Yes, sir.
Cape.
Yes.
While you motion to Altred and Charter, what's the connection?
The connection between Altrad and Cape?
All the parade of horribles and evil that you attribute to Cape.
Right.
We don't have Capes in this table, do we, or do we?
Well, the receivers going
All
to
right,
talk about.
that's what
Yes.
It's not a hard question.
Yes.
What is the nexus between the evil actions and motives you attribute to Cape and the two parties in this courtroom here today?
They are the amalgamation of Cape. They're an amalgamated entity. And that's what the underlying trial court was in the midst of trying when this happened. But for our purposes of Cape and the motion to appoint the receiver is appointed over Cape. The receivership is over Cape, and the Cape, and it's a shell game about what Cape's name was in various times. But the receivership is appointed over Cape.
And it was done in Parks.
It was done in Parks. Yes, sir.
And you believe it carries forward to Tibbs?
It has to carry forward to Tibbs. Here's why. It is a receivership that is for the benefit of the creditors. It is a debtor under our case law, under Virginia Chemical, under Welch. And there is not just one creditor. There are many creditors. We see it in Park and we see it in Tibbs, right? And there are many others. there are intangible assets here, and I want to talk about that. I believe there is insurance here that would cover these issues, and I'll show it to you.
We'll give you time because I think we all are interested, on what is it?
Sure.
Is it insurance policy? Is it other assets? They say there is no insurance, unlike Welch.
Right.
So, and I apologize earlier for interrupting you because you had a flow going. And if you want to return to that, if possible, then please do so. And we're not going to call you on time, just like we gave extra time to this side. We'll do as well to your side as well.
Thank you, Your Honor. And I appreciate the compliment on the flow. I'm gonna go back just a second because it goes to what you're talking about, which is what is it? What are the assets out there? The reason why a receiver needed to be appointed. So we made the motion to appoint the receiver in Park. That motion was served on Cape. Cape never to this day has come in and said, hey, we want to post a bond. We want this receivership to go away, which they could do. They could do it today. We want to actually meaningfully comply and participate in discovery. And in these cases, they've never done that to this day.
Did they participate in jurisdictional discovery?
They never even showed up. They never filed an appearance. They never filed an answer. So where Atlas Turner at least showed up and filed a motion to dismiss for personal jurisdiction, Cape never did that and still hasn't.
Well, they say Cape's never been served with anything.
And the record before Your Honor clearly shows, and Judge Toll went through it,
Was Cape to be served or CIHL?
they were both served.
And that's the information that talks about the bulk of material inside the envelope. It was too thick to be just one little piece of paper.
That's right. And so what the record shows, two things. One is that when we sent the process server the summons and complaint, it was one PDF document. The first 4 pages were the summons. The next 66 pages was the complaint. They were both served on Cape. He called it a summons, but it was the summons and complaint. That's the first thing. The second thing is the process server also said, Alltrad has set up a claims email for Cape UK victims. And the email address that's in the record is like alltraduk@claims.alltrad.uk. And the process server said he sent the summons and complaint to them. And guess what? Alltrad never came forth and said an affidavit saying we never get service of this. Cape never filed an affidavit saying we never got the summons and complaint. Clearly they were served with the summons and complaint. They were also served with the motion to appoint the receiver. And that's important because they've never shown up. The moral fraud continues. All right, so how do we know it's continuing? First, go ahead.
I'm sorry to interrupt your flow as well, but what's the theory behind trying to do all this right now before you have a judgment? Why, you've got Cape in default. Why don't you just get a judgment? That changes everything. And then go after assets to collect the judgment.
2 reasons. One, we know that a default judgment in the UK is not collectible, right? We can't go over there and the UK courts are not going to do anything with our default judgment.
Okay, well then make a motion for summary judgment and proceed to a hearing in front of the judge. Get a judgment. Doesn't have to be a default judgment.
But it's the same principle. Any kind of judgment that's entered into is not going to be enforceable in the UK.
Well,
So your reason for not pursuing a judgment is that a judgment is unenforceable in the UK.
That's one reason. The second reason,
Well, how are you ever going to get around that though?
okay, here's how. So if you look in the record, and this is much like, I'm sorry, it's much like the Welch case. What we don't know at the time a receiver is appointed is there is insurance. At least with Atlas Turner, we had old discovery answers that showed insurance policies. Here, we didn't have that. But what we do have, and if you look at the record, it is a letter from Ron Oren. And it is on, I'm sorry, I just want to give you the right site. All right, I'll come to it in just a second. It's on Alltrad letterhead. And it's addressed to Lloyd's of London, which is an insurance company. It's signed by Ron Oren, and he signs it as Director of Cape Intermediate Holdings Limited. Okay? all-trad letterhead, signed by Cape Intermediate Hold as the director for that. And this is where the receiver has sent a subpoena to Lloyd's of London saying, we understand that you may have responsive insurance policies.
Which receiver? This receiver?
This receiver. And Ron Oren, director of Cape Intermediate Holdings on all-trad letterhead says, do not give him that information. Don't do it.
Do tell us what page that's in the record.
Yes, sir.
So part of your answer for not pursuing a judgment is that you're trying to hook in the insurance company because you can deal with an insurance company.
That's right. So 5423 in the record.
Thank you.
That's right. And what I don't.
Well, I get that, but I don't see why that counsels you to not pursue a judgment. You can still engage in the same type of post-judgment activity that is now pre-judgment activity that is designed not to get Cape to just give you money, but to find out about insurance. I mean, take an insurance company, for example. You're not going to convince Lloyd's of London if there's a policy that covers, that is written to Alltrad that is by its terms and indemnifies Cape. They're not going to pay you without a judgment. I still don't understand why we're doing all this pre-judgment.
So I don't have a direct cause of action against insurance companies as the plaintiff.
Right, you
don't
got to
have
get a
that.
judgment.
Even if I get a judgment, then there's a non-cooperation issue with insurance companies where they don't have to pay because the insured has not been cooperative.
Well, they're going to say that right now. I mean, that case has been pending 5 years. So they're going to say that today,
Well, but
even before you get a judgment. So I don't understand. I know you said that to Justice Toll, but I still don't understand why that would be a reason not to go ahead and get a judgment.
So I disagree with you because where we are in the process is it would allow the receiver to come in to tender the policies to the insurance companies, to tender coverage, to come in and allow Cape to then put up a defense, which is what the receiver has been doing. It's not like he just collects this money and
All right,
gives it
so
out.
what you're trying to do is make the fight fair. You're trying to get to the point where Lloyd's of London, for example, would provide counsel that would defend Cape on the merits.
Exactly. What I want is a fair fight. I want them to come in and defend their conduct.
Well, I want to ask something that Justice Few touched on. I'm not asking about insurance.
Okay.
Let's say this goes forward. You get a judgment, amalgamation, all the causes of action. The receiver gets a judgment on all his causes of action. Maybe this is better addressed to Mr. DeLay. But why isn't that judgment dead on arrival when it gets to the United Kingdom because of Adams versus Cape? I mean, I understand that there's a difference between this court and the English court, but you're going to have to go there to get it enforced anyway. So again, why are we here doing all this if that's going to be the end game?
So I think this is a question that Mr. Lay is going to address, but what the receiver can gather are assets that are within the state, and that includes intangible assets
Within this state?
within the state. Well, and look, insurance policies that are outside the state can be included in that. Causes of action. I mean, I do want Mr. Lay to address that. He's going to address the scope of
So
the receivership.
when I look at page 3058 of the record, which is page 2 of the toll order appointing the receiver in Park, and it gives the receiver authority to, quote, collect all accounts receivable of respondent and all rents due. You read that as applying to South Carolina only?
So she has narrowed that receivership order in the Tibbs case. You know, after your June 26th order, she narrowed it down
Well,
a bit.
I mean, I think that the way you just were talking to Justice Hill, my question calls for a yes or no answer.
So I don't know what's out there, so I want to be careful answering it. I want Mr. Lay to answer that better because he's in the weeds of
All right.
what's out there.
Well, then we'll let Mr. Lay answer that. Back to what I was asking you a few minutes ago. I get your point about insurance. You want a lawyer sitting in the circuit courtroom over there in Richland County at some future trial who stands up and makes an opening statement on behalf of Cape, right?
Correct.
All right. Then I get why the receiver is after insurance. Why is the receiver after tangible property that belongs to these defendants over here, these third-party defendants over here?
Because it is part of the assets.
Right, but I mean, what?
the
back to
receiver-
in the context of why not get a judgment first and then go after those assets?
It's not required, for a simple reason, it's not required. It's not required when you have moral fraud like you have here under Section 5. It's not.
I
Otherwise-
don't know that I'm not positive you're correct about that. And if that's your only answer, I'll just leave it at that. That's fine.
It's not my only answer. The answer is, I don't know. I don't want to do harm to the assets. There's going to be more than one creditor within this receivership, right? I mean, there is. The way that Cape as a unit, when you look at it practically, there are thousands of victims out there of Cape. There's going to be one pot out there. And I think the receivership gathered those assets and can act as a person who can dole out, if they're paid reasonably. And there is potential insurance out there. So getting a judgment hurts that. It doesn't help it.
Well, I mean, if we had a Welch type receivership order that didn't allow the receiver to collect all accounts receivable of the respondent, then the matter would be simplified and you might not have to be standing there right now, but we don't.
So, because of the scope of the order, is that what you're saying?
Well, yeah, because of the fact that the order clearly allows the receiver to seek assets that are not related to insurance. And really, it looks like it, the way I read the order, especially in the context of how they respond to the order, which is that all the property that would be subject to collection here is actually in Europe somewhere. I mean, why are you messing around and wasting your time? And I chose the word, I think, waste purposefully. Why are you wasting your time trying to use the authority of a South Carolina court to change the locks on a warehouse in France? You can't do that.
Of course not. And the receiver
Then
has not.
why? Why are you doing it?
We're not doing that.
That's what this order says.
And then if you go and look at the receivership, number one, I think if you go and look, the receiver has not done anything like that.
Of course, the receiver has not done anything like that because it is legally and physically impossible to do.
So
That's what I got your point about insurance. That's a good point. But throughout this whole process, going back to Welch, going back to the June order, I'm sitting there trying to figure out why in the world are y'all messing with this? Why don't you just go? Now I got it as insurance, but why don't you just go get a judgment and then go after the money? Because you simply cannot send this order to France and expect that it could make any difference whatsoever.
and respectfully, this order is not going to France.
Well, then,
They have-
are there assets in South Carolina that the receiver could go after?
yes.
Well, then, okay.
But
Those assets are, for example, the insurance, the insurance
Right.
policies.
and he may find other assets within South
So
Carolina.
we were told that there's no insurance in this case,
Correct.
unlike Welch. You pointed to one that you believe represents the existence potentially of an insurance policy that would apply in this case. Is there any other insurance policy that you're aware of or other assets that are identifiable? And I'm using that as a transition to the bond, and maybe Mr. Lay's the one that's going to respond to the bond questions, or do I pose those to you?
Well, you can pose it to me and you can do anything you want to me, obviously. I don't read it like that, but
I think
Um,
we have asked you many questions that were not within the sphere that you clearly defined when you
Sir,
started.
Well, the way Mr. Rawl argued, I think convincingly, is that you are the one to answer the question about the bond. Because you have to, under his theory, which is not off base, the receivership is pointed at a specific asset that's the way it's supposed to be. So you should have been able to tell Judge Toll at the time you made the motion for the receiver to be appointed, what are the assets that you're after? What is their value? And here is how we intend to deal with this requirement of a bond.
So a couple of things about that. One, I don't believe they have standing to be able to raise this bond issue, period, under Ex parte Raleigh. It clearly says third parties can't do it. If Cape comes in here,
Yeah, but I
They-
think, like I told him, he's using that argument to illustrate the otherwise invalidity of the ability of the receiver to sue him.
respectfully, it's more than that. It is that the Cape has to be the one to come in here and do it, because when you have a party that will not show up, we don't know what assets are out there. So when they come in and show up, I think that they can set a bond. I think they're entitled to a bond, but we would be able to ask some questions about that.
Let me ask you something, and this is an overlay to many issues, and both sides have done this. You have a theory that links Cape to these third-party defendants, the parties here today, and you do it through some legal arguments of piercing the corporate veil, amalgamation, single enterprise theory, et cetera. So they're linked. But on the other hand, they're collaterally estopped. They cannot argue something that Cape can do. See, I don't think you can have it both ways. Either they're one and the same under amalgamation and they have every right to assert every defense that Cape has, or on the other hand, they're just separate entities and you're right. They can't challenge it.
Well,
What am I
Chief
missing?
Justice Kitchen, if they are going to agree that they're Cape, they can come in and argue anything they
Oh,
want
no,
to.
they do the same thing. They say, we don't know who Cape is. We've never seen Cape. We have nothing to do with them. But by God, we're going to argue everything that they can argue. So
Without
both
particip-
sides are doing that. And we're trying to figure out where does the dust settle?
Well, and I will let Mr. Lay address a lot of the amalgamation issues and all of that kind of
And if you
issue.
want to call time on yourself.
No, I hope I'm signaling I'm having fun. We're having a
No, yeah,
good time.
yeah. We're all
Um,
having fun.
This is allowing, my case is against Cape, right? That's how this started. And so when I'm looking at my case, I want to be able to try my case against Cape. What the receiver has done is said, let me try to identify assets that would help satisfy Cape claims. That's what he's doing. And so there's a little bit of overlap here. I am not in this third party case, right? My case is against
Right.
Cape.
And I've seen that people who installed, people who made equipment, they're all brought in. But the people who sold the asbestos escape.
Right. And they did it by hatching a scheme. It is Atlas Turner's conduct on steroids. It really is. And if we allow them to get away with this, then why wouldn't every company do it? Why wouldn't every international manufacturer or seller do the same thing that Cape did?
Do you want to respond about the bond issue?
Uh,
Or do you want Mr. Lay to handle it?
I think I'm going to respond in that I believe that everything can be valued, but I think Cape is the appropriate entity to come ask for that so that we know what their assets are. I think Mr. Lay will have something more to say about that, but that would be my response to the bond issue.
Okay, there may be some other questions.
Yeah, I want
Yeah.
to go back to this apparent breadth of the order. So you asked for the receivership.
Yes, sir.
You filed the motion,
Yes, sir.
and the order was drafted in response to your motion. Do you contend that the receiver under this order has the authority to act outside of South Carolina? I'm not talking about insurance. I'm talking about bank accounts. I'm talking about real estate. Does this receiver have the authority to act outside of South Carolina under the terms of this order?
So that's a question for Mr.
That's
Lay.
a question for you.
Okay.
Because you are the one who asked for the receiver. You're the one who drafted the motion. You're the one who convinced Justice Toll to sign the order. And you're the one who's going to answer the question.
I believe that they're intangible assets within the jurisdiction of South Carolina. He can get to those.
Okay,
Now,
tangible assets.
yes.
All right. No, within South Carolina, of course, but tangible assets that are not within South Carolina. Hire a real estate broker to sell any real property. Is that limited to South Carolina or not?
I don't know that it is limited to South Carolina. I think if you look at the Welch opinion, what the receiver does is they stand in the shoes of the company. And if he could if the court has jurisdiction over Cape, which they do here, they can bring to bear in assets that are outside of South Carolina.
How about outside of the United States? No, I'm talking now, I'm just going to talk about sell real property. How about outside of the United States?
I don't think so.
It doesn't apply.
No,
All right. So the real property applies in the United States.
right.
What about the other ones? Open any mail addressed to the defendant.
I don't think so. I mean, they're not, if there was mail that was in South Carolina that was coming to deal with that, I believe that he could.
So to me, the scope of the order is important. And to
Sure.
them, the scope of the order is important. And so I'm trying to get a clear answer from you about, and you're answering it. But is there anything in this order that any act that the receiver has been authorized to do that can be conducted outside of the United States under the terms of this order?
I don't think so. And, you know, I just want to say too, I think when we start a receivership order, and you saw this in Mr. Ashmore's amicus brief, the order starts inherently broad. And as the case goes on and you can identify what potential assets are out there, the order gets more narrow. And that's what happened here. If you look at her Tibbs order, she makes it much more narrow.
Justice Hill,
Ms. McVeigh,
Yes, sir.
the leading case, I think everybody agrees on, pre-judgment receivers based on moral fraud is the Virginia Chemical.
Yes, sir.
So in that case, the court said, when a debtor is trying to defeat his creditors by an act or course of conduct which indicates moral fraud, conscious intent to defeat, delay, or hinder his creditors in the collection of their debts, then equity will step in and within jurisdiction, appropriate and effective to protect creditors against the fraud without requiring the creditor to run the risk of losing his debt from the delay of obtaining judgment and a return of nulla bona execution. So it isn't time of the essence when you're talking about a pre-judgment receiver.
It is time is of the essence.
Okay, so this thing has been going on for 2 years since you've got a receiver appointed. So that goes back to what Justice Few is talking about. Why don't you just go ahead and get a judgment? And why would we approve a pre-judgment receiver being put in place when time is not of the essence here?
Well, Your Honor, respectfully, time is of the essence. And one of the reasons why it hasn't been faster is because and I don't want to go back to the interlocutory appeals, but a vast amount of interlocutory appeals that have happened in this case. I mean,
There's 16 of them, I counted.
16, that's outrageous. And so that's why this has taken forever, along with the non-cooperation of these third-party defendants in the trial of this case. This would have been over a long time ago if people had done what they were supposed to do under the civil court rules.
The non-cooperation of those folks in the trial of your case?
In the trial of the third-party case. In the trial of the third-party case, they have,
Why does that slow you? I mean, I guess your point that the only way you can really get to Cape is to have counsel appointed for them or chosen for them by an insurance company who's obligated to do that and try the case on the merits.
that's right.
So that's where you want to get.
That's where I want to
And
get.
then, I mean, to me, I still wonder why you're pursuing the real estate prejudgment, but because you can't go get a judgment so you can collect the real estate and then subsequently try the case to a jury to get the insurance.
That's right.
You got to do it one way or the other.
And it's all got to be together. I mean, it's got to be kind of, we need to have one trial against Cape, but the assets, what's available to pay a judgment needs to be identified.
What if the situation were that you have a receivership order,
Yes, sir.
and that order allows the receiver to go after all information that he or she can find related to insurance coverage in the prejudgment phase of the case, but then to hold off on going after other assets until after a judgment has been entered. Why would that not be a satisfactory resolution to the dilemma that you face from Cape's conduct?
So two issues. One, the receiver's job, in my view, and under our case law, is to marshal the assets, all of the assets. That's number one. And that's important because I don't know what insurance is out there. We believe that there's insurance based on the limited information that we have in this record.
You have this, your belief, of course, is that there's no possibility that if you were to ever get a lawyer in the case and try the case on the merits against Cape, you believe there's no possibility that you lose. You're going to win.
Not
Now-
against Cape, right? Yeah. Some of my, I've lost plenty, but yeah.
It's been 26 or 7 years since I tried cases. Looks like I'm gonna get the opportunity to do it again soon. Ain't no case that you have 100% chance of winning. There's no case out there that you have a 100% chance of winning. What if the receiver goes out there and marshals all this real estate, and then you lose the case?
Sure. So I could lose one case against Cape. I could lose two cases against Cape, but there are going to be thousands of cases against Cape.
My point was, it was a rhetorical question to illustrate what I believe is the hard reality that you simply can't go get non-insurance assets pre-judgment, period. That's what I believe. And I understand, like, you articulate your dilemma convincingly, but there might just not be anything that the state courts of South Carolina can do about that.
And
And you
respectfully.
can answer that and then
I'll
we'll
sit
move
down.
on to
I'm sorry.
Mr. Lay.
Yes, sir. I respectfully disagree with you. I think that the receiver has the ability to marshal these assets and that claimants have the right to get them if they're entitled to them. And I apologize. Thank you for the extra
Oh,
time.
We apologize, but we want to try to unpack this and learn as much as we can. Good morning, Mr. Lay.
Good morning. May it please the court. I'm John T. Lay. I'm here on behalf of the receiver. This is the rarest, this is the most extraordinary circumstance that calls for this limited Title 15 receivership. I want to address one thing, if you can just indulge me. The appellants in this case have breathlessly asserted that if this receivership is not dissolved, it will cause an erosion of the rule of law, that it will cause people to think that the South Carolina courts are corrupt. And I want to address that directly. The Cape is part of a group of companies, and we're in the midst of the trial on this case, but they're part of a group of companies that acted in concert. This is a historical fact, and we've been able to prove it. There have been books written about it. It is a unique economic model that emanated from South Africa, and it's top-down control. And there are companies above Cape that dominated, controlled, and they were all part of the sale of asbestos into the United States and directly into South Carolina. The Cape and the companies that dominated made the very cynical choice. They put in 90 to 95% of the asbestos into the United States. Brown and blue asbestos. That's the stuff that kills you. That's the most dangerous form of asbestos. Every plaintiff that has meso in the United States has Cape asbestos in their body. That's Cape asbestos as part of this amalgamated enterprise. If you look at what the group system is, it equals amalgamation. They were all acting in concert. So Cape, even though, and the companies that dominated it, even though that they are having access into South Carolina, they are trying to get into, they're coming directly into South Carolina ports. They are direct sales into South Carolina. They've availed themselves of our market. They do not want to be held accountable for the harm that they've caused, and it's profound harm. In fact, they made the very cynical decision to flee the jurisdiction, liquidate one of their distributors, create another one the next day. They created a company in Europe to be between Cape and the Cape entities and the distributorship. And they did that, and they wrote this down to camouflage from U.S. plaintiffs that they were still in the U.S. market. So it's as bad as it gets, and it
Well, you say that, you
continues.
say that's moral fraud, right? Isn't that part of the argument?
Well, part of what it is part of it, and it's continuing moral fraud, absolutely. And I can tell you some of the continuing moral fraud that is going on very directly.
Okay, but the United Kingdom courts say it's perfectly legitimate corporate activity. So it goes back to what we were asking Mr. McVeigh. What is the end game here? Let's say you win your case in Tibbs, and you got a judgment. You've amalgamated them or pierced the veil. You've got a judgment for accounting, constructive trust, unjust enrichment. You win, home run.
Yep.
What's going to happen when you go to try to enforce it?
I think there is a couple of different steps that will be taken after that. If we get a ruling that there is an amalgamation so that these companies are responsible because of their successors to companies that were amalgamated with Cape, that sold this asbestos, that were part of this plan, then they're going to have responsive insurance assets to South Carolina plaintiffs that have asbestos claims. There's going to be responsive insurance buying through those companies because of the amalgamated interest. That's what we think, and that's what we're going to try to prove.
One-stop shopping here, and you don't have to go to England to enforce it. Is that correct?
That's correct. In fact, we probably would not be able to enforce it. We are a limited Title 15 receivership over assets that are in South Carolina. Those assets are intangible assets. There are causes of action, not choices in action. There are causes of action, and there are also the Cape insurance assets, which we have been thwarted at this point. They have stopped it. They're hiding their insurance assets. But it's also potentially the insurance assets intangible assets, insurance assets that we would get buying through these equitable claims. That's the plan. We are in step one of that process. We did an investigation. When we initially got involved, it was going to be to pursue the Cape insurance. Then we discovered these other equitable claims and pursued these other equitable claims that can create additional insurance assets.
Well, what about their argument that those causes of action are board decisions to whether to bring them or decisions of the internal affairs of the corporation?
That's not the law. There are several cases that we cite in our brief: the Edgar case, the McDermott case, the Calico case out of California. The board decisions, that's a term of art. And that term of art is talking about the relationship between the CEO, the directors, the shareholders. It's things like bylaws, operating agreements, that sort of thing. It's not litigation. And there's no case in the U.S. that says that would be part of it. It would eviscerate, in effect, Rule 66. That is not a board decision. So I don't think much of it because there's no case law to support this position that it's somehow a board decision. It's just not. But the Title 15 receivership here is limited, and there are guideposts around it. There are guidelines. What the plaintiff in this case, or the appellants in this case are trying to do is to drive all of this Title 15 receivership into Section 1 of the statute, that it's a pendente light or lite, or however you pronounce it. But it is a very specific type of receivership. That's not what this case is. This case is a Section 4 and a Section 5 receivership. They committed moral fraud. We can prove it. It is continuing. Cape, since we have been appointed, Cape has continued to do something with its assets. It's a company that does not have any assets on a regular basis. It's a holding company. So money gets upstream to it for a moment each year, then it immediately goes out. So it is a company that is potentially in danger of insolvency. We have tried to get to insurance assets, and Cape/Altrad, Rand Oren, who is the sole director of Cape and is the CEO of Altrad, writes the carriers that we have issued valid subpoenas on and said, don't you dare respond. It's against the law.
Who are the named insureds of those carriers?
We don't know. I mean, we think
Well, you
that
said he
Cape is the named insured because we sent a subpoena to find out what Cape's insurance was. And in response, the CEO of Altrad / the sole director of Cape writes a letter. We got an initial response for Allianz, a company, one of the insurance companies, and says, we got information. Then the Lloyd's folks also had a subpoena, and Rand Oren writes to both of those carriers and says, don't you dare provide any information. So we're getting blocked right now, and we're going to do something about that. Right. They also have a something called a scheme of arrangement that is a UK creation where there is a fund that is available for UK plaintiffs. So it's plaintiffs in the United Kingdom that have some sort of asbestos. It excludes everyone else. It's just UK. We think that came about because they liquidated insurance policies and then they have just limited it to the UK. That's reducing, dissipating assets.
Well, that reminds me, in reading Justice Mann's order that enjoined the receiver, he was talking about that scheme, and he also said that there was part of that fund that was designated for United States claimants. Tell me about that. Is that he
Well,
just
that-
wrong?
I think he's wrong about that because we have not seen that. That information has not been provided. Now, and this is part of the issue that we have in this case. We get appointed receiver. They are not responding in any way to anything that we're doing, not even jurisdictional discovery. There's been a prima facie finding that there's personal jurisdiction, and really it cannot be debated that Cape is subject to personal jurisdiction in South Carolina. They had direct sales. There was an overwhelming amount of raw asbestos pouring into South Carolina. We've shown it. The prima facie case is there. We are trying to get additional information from Altrad, from the ESAB companies to understand what the jurisdictional situation is. Is there other information out there? We've been thwarted. We have not been able to get any information, not one deposition, not one document. They've even responded to motions for summary judgment. The charter defendants filed an 800-page response to a summary judgment, and they haven't engaged for 1 second in any sort of discovery in this case. So,
Mr. Lay, if I could, I apologize. I'd like to back up.
yes, sir.
Assume, just for the sake of argument, that the appointment of a receiver pre-judgment was appropriate.
Yes, sir.
I want to focus on questions that have been asked, particularly from Justice Few, as he was reading a litany of so-called authority and power that was given to the receiver to sell property, to open mail, to place a lock on a business in France or wherever. So the scope of the authority may be something that we have to deal with if we overcome the threshold challenge. Has the receiver sold property?
It has not.
Has the receiver opened the mail of?
We have not.
Has the receiver attempted to go anywhere, either in America or overseas, and place locks on doors or businesses?
We have not. So
So even though the court purported to give you, I'll say it charitably, broad authority, there's never been an effort to abuse that.
correct.
And the focus, you're saying, has been limited to assets, and we're looking for insurance policies. Is that correct or not correct?
That is correct. We're looking for insurance information, but we also have the intangible asset of the causes of action. That could lead to other insurance. It could lead to other assets if they're part of the amalgamated enterprise. But have we done anything like what you're describing that was put into that appointment order? No, we have not. We have limited ourselves to this litigation and trying to establish these causes of action, and also trying to explore whether or not these insurance assets are out there.
We're going to go over and allow other questions because other members may have questions. Mr. Lay?
The modified order, October 13th, doesn't have any of that in there anyway, does it?
It does not. The modified order allows us to pursue those intangible assets. It allows us to accept service of complaints that are coming in. It allows us to investigate and hire lawyers like me to defend the receiver in the case, and any other professionals to help us get to the bottom of what the insurance assets are. So it is a limited, the Tibbs order modified that appointment order pursuant to some of the instructions, the guides that we got out of the Welch order, right, out of the Welch opinion. So it is very much limited now, which is not unusual in the way receiverships go. It is an organic process. It really does start broadly. We have a supervisor. We got a policeman on this, which is the court. The court is making sure that the receiver is doing what they're supposed to do, and she either approves it or she doesn't approve it. And there are times when she does not approve it. So in that order, as a result, the appointment order can contract, and it contracted in this case. It has become a more limited appointment order as a result.
You
Is
say
it-
that one of,
Is it like the hypothetical two-step order that I proposed to Ms. McVeigh, where the receiver has the authority pre-judgment to go after insurance assets, and the whole going after physical assets or financial assets that are not insurance policies is held off until after a judgment?
Well, I think we need to go after these equitable claims, and we need to do it right now.
Okay, separate out equitable claims. Separate out equitable claims to try to get these entities amalgamated. Separate out insurance assets. You can do that pre-judgment. Post-judgment is any other assets such as those that are listed on this page that have been taken out of the order as it stands now in Tibbs are limited for post-judgment.
I think you could do that.
Would there be any, if we look at the awful picture that has been painted, not only by you, but by Ms. McVeigh, of what CAPE and its affiliates are doing, if we structured the order the way you and I are now talking, would that inhibit the receiver's ability to accomplish the receiver's purpose as set forth by the trial court?
We would be able to pursue the equitable claims if we can do that, and we're able to access insurance information. That's what we're trying to do right now.
Well, so you're telling me yes, comma, and then you're proceeding.
Yes,
I
I'm
mean,
saying
no,
yes.
you're telling me no, it would not inhibit the ability of the receiver to do what the receiver is appointed to do.
Answer very directly, I think that's the case. The second part of that, though, is are we able, as part of pre-judgment, to pursue in-state assets that are real property? There may be in-state assets. So if as it relates to in-state, yes. If it's an in-state, for example, Altrad has interest in Williamston, South Carolina. ESAB had headquarters in South Carolina. We think they got South Carolina assets. So the extent that there are assets there, I think we can look at those. But the case right now
would it
is
not
what
be,
we're talking
would it
about.
not be, it would be proper, to say that if there's one plaintiff out there with a judgment against Cape, if you win your amalgamation claim, then the receiver can go after those assets, even if doing so for the potential future benefit of some plaintiff who doesn't yet have a judgment. That'd be proper. Why, is there anyone that the receiver, I don't know, acts on behalf of or somehow is connected to this case that does already have a judgment against Cape?
There is no one that we know of that has a judgment against Cape, certainly not in South Carolina. And if we did do this through a judgment, you're voiding insurance. We're not going to be able to get insurance assets. That's the problem with that. We have the ability
Well,
to,
I know, and that, to me, that fits into why we should
Yes.
have this two-step process.
well, that's what we're trying to do. We're doing it in a two-step way. We're trying to find out what the insurance assets are, and we're trying to establish these amalgamated claims. And in its successor liability, it's veil piercing and its amalgamation, which is effectively a derivative claim that comes about because derivative claims is coming about because of the claims directly by plaintiff's counsel against Cape. So that is the way we're moving forward on it. But in my opinion, we cannot get a judgment. If we get a judgment, a big portion of the available assets may go away.
And that's because of the non-cooperation clause.
Yes, sir.
All right, so if you succeed on the amalgamation claim, you're saying that that would potentially bear fruit, and the fruit would be other insurance where these entities, the appellant entities, are the named or the insureds, and also potentially hard assets in South
Correct.
Carolina.
Potentially hard assets. That's
All right.
correct at that point.
Ms. McVeigh said that would also include your ability to go after hard assets in other states in the United States. Is that correct?
I think we're
Or is
limited.
that a post-judgment issue?
I think going after assets out of state would probably be a post-judgment issue. Right now, we are just a receiver over the in-state assets.
Okay, so if you got a gazillion-dollar judgment against all of these amalgamated entities, you'd have insurance, potentially hard assets in South Carolina, and more potentially hard assets in other states or territories.
Yes, sir.
All right.
And I also want to point, and I don't want this lost, the moral fraud is continuing. I mean, you have Central Mining, that's one of the defendants in this case, that since we've been appointed receiver has been decapitalized.
Okay, and Mr. Rawl said the word dissipate probably 20 times.
Yes,
He
sir.
said, you have to show it's being dissipated. And he said, can they show it's being dissipated? And that was his bootstrap for a long litany of answers he gave. Tell us about that. What are
Well, I think it's more-
what is at risk of being dissipated or actively being dissipated now?
So I think it's a little more nuanced than that. It's hinder, delay, or
Okay.
defeat. So
right.
it's a bit more than that. But the things that have occurred or are continuing to occur during this 2-year delay because of all these interlocutory appeals.
And if you prevail in this case, there'll be a petition to the U.S. Supreme Court too for another period of time, correct?
My guess is they're going to do that. There's no
all right,
constitutional
so
issue in this
I
case.
interrupted you there, so go ahead.
Sure. The things that have occurred in the 2 years that this has been going on is, number one, they've been hiding insurance. We haven't been able to get to it. That is delaying. They have decapitalized one of the companies that is a defendant in this case.
Which one?
Central Mining has been decapitalized. The release is this collusive release that they did is impacting the assets. If they won that, which they can't, but there's an attempt to dissipate those assets, it eliminates those assets to be accessed by South Carolina asbestos plaintiffs. So this, and then we still have the scheme of arrangement where they're already, we believe, they have already limited South Carolina U.S. plaintiffs from being able to access these funds because it's limited to just the UK.
Are they doing this, or is Cape doing this in other states?
I'm not aware of any other litigation currently involving Cape, so I don't know. But since the initial litigation where they participated, the one and only time in U.S. litigation. There have been 4 or 5 cases in other jurisdictions where they found that there was an amalgamated, they were all in concert, but nobody's been able to do anything with it.
I thought there was a pending case in Richland County by Pittsburgh Corning Trust. in this
You
case.
know what? I apologize. I was thinking of it in just South Carolina. Pittsburgh Corning has a case, and then another lawsuit has been filed, and Cape went into default on it. So they're continuing with this, failure to respond in South Carolina. They got served and through the Hague Convention, and they haven't responded. So there are 3 or 4 cases in South Carolina, certainly, that they have been non-participatory in.
I don't want to catch a cold, but, and you might not know, so you can just tell me. But what are the allegations in the Pittsburgh Corning Trust case? Because that's brought by the receiver too, right?
That's not brought by us. It's brought by the trustee of the Pittsburgh Corning Trust is bringing they've paid claims over the years. So they have,
I thought there was never mind. It doesn't matter who the lawyer is. Do you know what the claims are?
I think the claims of that. I got it.
Is he translating my question to you?
He is. You want me to bring it back? So they have paid 1,400 meso claims, and they're looking to see in South Carolina, and they're looking to Cape to see if there's some sort of indemnity back to be able to, compensate those folks. So it's 1,400 different South Carolinians have made a claim against that trust over time. Can I directly address the bond issue?
Please do.
Yes. So, there is a requirement of a bond, but the way this works, and this is the reason for In re Raleigh, in my opinion, you have moral fraud that is occurring. You have a company that is hiding assets. So by definition, it's hard to know what all the specific assets are. So I do think this is probably capable of valuation, but what you would contemplate in a situation like this with moral fraud is the entity comes in and says, I need a bond. And there is a discussion about what the value of that bond should be. And then that has to be offered at that point. And then the bond can be paid. In re Raleigh is saying, look, because of that process, you got to have a bond. The person that's going to know the information is the entity over whom the property is in receivership. They're the only ones that complain about it. Because if they complained about it, they would be brought into court. They would be able to have a discussion about the bond, and then the bond could be paid. That's the way it's supposed to work. That's the mechanics behind it. They try to act like it's some sort of fatal condition precedent. It is something that has to be offered, but there's a process to that. And there's nothing that says otherwise. Don't forget where we are. We are in a court of equity with this receivership. We are equitably trying to deal with these things, and it's not a game of gotcha. I look at what they have, the rules that they put in place in their, what they suggest the rules that should apply to receiverships are. It would eviscerate 4 and 5 of the receiver statute. There'd be no need for 4 and 5. We are all pedente light. That's what they're trying to drive it to. And isn't that convenient for a company that has been, engaged in moral fraud to hide their assets? This is just bringing everything to the table to be fair. Yes, sir. You got it.
Follow up on that. If you're not seeking pieces of real estate, but you're seeking insurance, you're seeking to proceed with your equitable causes of action against those you believe should be lumped together, amalgamated with Cape. Would it not be true that there's no value that you're pursuing that could give rise to a bond?
Well, I think you could, I personally think that you would be able to value, if we had Cape in here, what are the insurance assets that are?
But I guess my question should be, why do you even need a bond in the first place if all you're doing is trying to get insurance assets? There's nothing to protect. The insurance assets are never going to be at risk until the court rules and the litigation unfolds. So there's nothing to protect. It's unlike a bank account where the company would be entitled to use the money in the bank account. And because they can't use the money, they should be protected pursuant to a bond. So I'm simply asking, as I was earlier, why are we even talking about a bond? Because if you're not pursuing a piece of real estate in Williston or a bank account in Topeka, it's a question that they'll have to answer on reply, but what is the value that even needs to be protected through a bond? And I would imagine that you would say none.
Well, I agree. It's none. But they have to come in here and respond to that. If they have some
Yeah.
reason for it, then they have a due process ability to have the receivership lifted. But I agree with you, and that is an alternative argument. You don't need a bond here. We're trying to establish what the insurance rights are, and we're trying to establish what these equitable claims are. So, but if we had to establish a bond, that would be part of the conversation.
One
with
more
the
hopefully
entity.
quick question.
Yes,
On
sir.
this idea of insurance, I mean, obviously, if during the work of the receiver comes up with a Lloyd's of London insurance policy that lists Cape as the insured, you can use that. If you come up with an insurance policy that lists Alltrad as an insured, what are you going to do with that? Are you after that? And if so, and if you find it, how are you going to use it?
I'm absolutely after that.
All right.
And Alltrad has U.S. assets that we would be able to access. But if Alltrad is found to be amalgamated with Cape, everything that Cape did, Alltrad as successor of Cape is going to be responsible for,
Even through insurance?
even through insurance in our view. And
Right.
it's certainly other assets. We would be able to get other assets at that point if we're able to prove that up.
Mr. Laywood, did you have a, Justice Hill has a
One more
question,
question.
and
Go
then the
ahead.
final question will go to
Well, no,
Justice
go-
James.
Justice James, go ahead.
All right, Cape Asbestos was founded in the 1800s, right?
Yes, sir.
And then it became a holding company, then it became Cape Industries Limited, then it became Cape Industries PLC, and now it's Cape Intermediate Holdings Limited. Mr. Carroll, at the very beginning of his argument, said, basically, even if everything they say is right, CIHL has never been served with anything in this case.
That is completely wrong. It's
All right.
not true.
And just briefly explain that to me.
Okay, and this is more of a Ms. McVeigh, but I'm going to give it my best shot here. Cape Intermediate Holdings is the company that sold asbestos for the last 130 years. That was identified, and what the court found, what Justice Toll found, is that when that complaint was sent, it identified in detail historically which Cape entity we're talking about. There's willful ignorance on this side acting like, and I'm going to explain why I say this side, but there's willful ignorance where they're acting like a company that was created in 2011 out of Jersey, which is an island off UK that I didn't even know existed until this lawsuit. They're trying to act like, oh, we're confused. This is the company that was served. No, it's a misnomer issue. It's classic misnomer. We have identified the asbestos company that sold asbestos for 130 years, whose name was Cape PLC until 2011, and then it changed names in 2011 to Cape Intermediate. They took that Cape PLC and made a new company. But that new company was not the company that engaged in the sale of asbestos for 130 years. Everybody knows it. Everyone knows it. And that's what the definition of misnomer is. That's what the court found.
All right, Justice Hill had a final question for you.
You reached a settlement with some of the third-party defendants.
Yes, sir, we did.
So in some of the briefs, I read that one of those defendants, someone alleged, is basically who owns everybody. Is that right?
Say that again, sir.
One of the defendants you settled with, supposedly in the briefs that was mentioned, actually is at the top of the pyramid here? Oppenheimer or whoever it is?
It's Anglo-American.
Anglo-American.
Yes.
You've settled with them.
Yes, we did.
So why didn't that just end the case?
Well, amalgamated, it's not just, our allegations are not just that it's Anglo-American. They're all acting in concert under the amalgamation claim. So they're all in it together. That's the definition. They're intertwined for a misjustice. And we're responding to that. So that, I don't think that ends the case.
Okay, and that settlement involved insurance coverage? Or
That
can you
was a
not say?
direct-
You might not be able to say, I don't know.
Right. Thank you. So it is not part of insurance. We weren't allowed to ask and they wouldn't tell us. So it was a payment made on behalf of the Anglo-American entities.
Thank you.
So we have a QSF set up.
We went way over and appreciate your patience with us.
All right. Thank you very much.
Thank you. We're now going to move to reply. Mr. Carroll, I think you have first opportunity.
Thank you, Mr.
Thank you,
Chief
sir.
Justice. There's a lot to unpack here, but I want to pick up, Justice James, where you just left off. Let's be crystal clear about this. CIHL is not a party to the Tibbs case. We're here on the Tibbs case. The receivership over CIHL supposedly is in the Tibbs case. And this is why I began by saying this. The presentation from my adversaries has basically been CAPE, a generic term they're throwing around. CAPE is bad. We should do something about it. So let's just make a receivership, let them gobble up assets like a roaring lion roaming around, and let's let South Carolinians come to this benevolent receiver to get paid. Isn't that, let's make, Chief Justice, you said, let's make it one-stop shopping. Due process stands right in the way of that. And that's why we've begun our briefs by saying, I understand the court is the audience for our brief, but so is our opposing counsel. That's why we've begun our briefs by saying rule of law, right? I understand the emotional appeal of coming in and saying, hey, asbestos is bad. There is a company in South Africa, which by the way was not Cape Intermediate. It was a company called EGNEP, E-G-N-E-P, and another company called CASAP, C-A-S-A-P. Those were the mining companies. They're the ones that sold their asbestos to NAC, a Chicago or a company in Illinois. And I'm not just shooting from the hip. This is what the Adams case was all about. Adams took up this whole notion of amalgamation, this group structure out of South Africa. And wow, isn't that a unique thing? And shouldn't we just treat them all the same? The Adams court looked at that. It picked through the evidence in granular detail. The appellate court wrote a 40-page appendix that took every fact you heard and responded to it and said, you were off by a degree. There was the acknowledgement of the corporate form of NAC. NAC had its own directors, its own pension system. It had its own accounts. It couldn't bind anybody else to contracts, and the list goes on and on and on. And the court said, look, that's just the way corporate forms work. If there's something fraudulent, we will pierce the corporate veil. Adams says that. It's on page 539 and 540 of Adams. It's this notion that like, well, gee whiz, English law is just different. It's not. The Adams court went through this whole analysis. And so it is evident that this receivership model that my adversaries are asking you to adopt is designed to just end run Adams and end run due process. Ms. McVeigh said, hey, this is for the creditors. She kept using that word creditors. There's not one creditor in South Carolina who's ever asked for this receivership, nor, might I add, is there one plaintiff in South Carolina who's ever asked for this receivership. This
Let me ask
receiver,
you a question.
Yes, sir.
Have you been asked in discovery whether or not your client is aware of any insurance policies that could be read to indemnify CAPE?
So
Yes or no?
my answer is I do not know, and I'm not trying to dodge the question. Here's here's why I'm answering it that way, because I honestly do not know. And because there was never discovery served while the case was at while the case was at the circuit court, there was no discovery in play. Chief Justice Toll denied the receivership appointment or the motion to
That's
dissolve the
enough.
receivership.
Let me go back.
Yes, sir.
If you were asked in discovery whether or not your client is aware of any insurance policies or insurance assets that might indemnify Cape, would there be any reason that you can think of that you should not answer that question straight up?
Absolutely. There's 13 reasons. Number one, the person supposedly doing the asking has no authority to ask. And look, I've heard the word insurance more in the last 2 hours than I did in 2.5 years of litigating this case. The receiver sent a subpoena to Lloyd's asking for any information about whether or not it's got Cape coverage. Mr. Oren wrote a letter to Lloyd's and said, hey, you need to be aware. He didn't say there's coverage, but don't tell him. He said, you need to be aware, English company, Lloyd's, that Justice Mann wrote an order in England that said that English law doesn't recognize this putative receiver. Nevertheless, the receiver pursued Lloyd's here in South Carolina.
You're moving away from answering his question.
Right.
Let me see if I
That's
can
right.
square it up better. Do you know if there's any insurance that would indemnify Cape? Yes or no? Do you know?
Do I know?
Or do I not have authority to ask you that question?
I do not know. I would have 99% belief that there's absolutely not, because why would they?
Okay, so the answer is not to say there are 13 reasons that you wouldn't have to answer that question. The true answer is you say 99% chance no.
Well,
That's your answer.
Correct.
And your answer is also, but I don't know.
That's right.
Okay.
But Justice James, just to be clear, my response to Justice Few was what I answered the discovery response, not do I know. And I wouldn't answer the discovery response because the entity propounding it is this receiver.
All right, what if we determined the receiver was properly appointed? Would you still ignore the question? We deny your request to dissolve the receivership. Would you answer the question then, or would you proclaim allegiance to the UK order?
I'm confident my clients would proclaim allegiance to the UK order
And tell you not to answer it,
And let me,
and
yes,
you'd
sir.
be held in contempt.
And then we would probably be right back here. But I don't want us to get in that spot. And let me tell you why I don't think we will ever get there. Okay. The whole conversation this morning has been about a Cape receiver. This whole situation begins in Park. In Park, the plaintiff, regardless of whether they served the correct summons and complaint, let's skip that issue. The Park plaintiffs named Cape PLC and CIHL as separate entities, separate defendants. They knew that these are different companies, right? Like that's indisputable. It's in their complaint. When the Park plaintiff, 9 months after they reported that the case was fully resolved to the circuit court, and 6 months after the estate was closed and the personal representative's appointment was terminated, and the plaintiff didn't even exist anymore. 6 months after that, a motion got filed in a case with no live claim, no live defendant, no live plaintiff. A motion got filed to appoint a receiver over not both, but only Cape PLC. All right. So that's where this whole situation starts. When I say CIHL is not a party to Tibbs, I am 100% accurate on that. Yet everything about the CIHL receivership has come in the Tibbs case. CIHL
Well, you
is
know,
not a defendant in this
everybody
case.
wants to be called by their correct name.
Oh, it's
But when you change your name dozens of times, you kind of assume the risk that somebody might make a mistake.
It-
Okay, so the law is pretty clear on misnomers of a corporation or a party. You can correct that. The court can correct that. Unless there's been some the corporation that was misnamed was somehow misled. They aren't even here to say how they've been misled. So how can you make this argument?
Justice Hill. This is not a case of misnomer. They knew both names. They
You've
booed
been
both
saying they
companies.
got the wrong name. So what do you
I'm not
call
saying they
it?
got the wrong name. I'm saying they got the wrong company. And well, Your Honor, respectfully, the Porter v. Brown case tackles that issue head on. There you had a opera company in New York, pardon me, in Florida. The receivership order was served on the correct agent for process, but the document appointing the receiver identified the New York or an opera company in New York when it was really in Florida. And this court didn't say, oh, well, that's misnomer. This court said that is a coram non judice, a action that's not in front of a judge because it cannot exist as a matter of law. That's not a misnomer argument. This court has already answered that question. But this really does matter. These are different companies. And CIHL, everything you heard about, we need to make a one-stop shop and we need to create a situation where plaintiffs can just come and sue CIHL. All that's being done in the name of CIHL. They're not a party to this case. That's due process. Mr. Lay said, well, there's no constitutional issues at play here. Of course there are.
This-
Due process.
This situation is frustrating. For a whole series of reasons, but I think that, to me, you know, you're talking about technicalities. Yeah, you are. You're talking about, Justice Hill just had a conversation with you about whether somebody was misnamed or misidentified. If they're misidentified, that's important. If they're misnamed, it's not. But the whole thing starts, this whole situation that we're in starts with allegations. We have not heard the proof. Justice Toll has not yet heard all of the proof. But the allegations are that the defendant who manufactured all of this asbestos and shipped it into South Carolina made a conscious decision some long number of years ago to evade liability for its conduct through these series of practices. It's impossible for us to sit here right now and know whether that allegation can be proven, but that allegation needs to be litigated.
And it has been litigated.
It needs to be litigated in South Carolina.
Your Honor, that's the Adams case. Adams
Adams is a Texas case. This is South Carolina.
No, Adams is a UK case where
All right.
there was, well,
Right.
look, I understand there's no treaty between the United States and the United Kingdom that says a decision here counts the same as the
Let me
decision
just
there.
continue with my train of thought.
I'm sorry.
Sorry. To the extent that it's provable that Cape has done this, even if the UK case and the Texas case are to the contrary, there is some really horrible stuff that is prohibiting people with mesothelioma and their families after they die from being compensated for asbestos, which nobody, as I understand it, nobody contends anymore that asbestos is not what it is. It was a wrongfully developed, the dangers of it were concealed, and it has killed people. So when I think about this case, the starting point is that there are credible allegations that Cape, or whoever they used to be called and should be called now, is deliberately and overtly I can't think of the word that I should use, but they are avoiding the legal process that every other defendant is supposed to be subject to. And the word I'm thinking of should be a bad word. I just can't think of what the word is. With that starting point, it's hard for me to imagine that a trial judge in South Carolina should not be cut loose to figure this out. And y'all have filed 16 interlocutory appeals? over every, if the judge schedules a hearing for 8:30 instead of 9, do you appeal that? I mean, that's a little bit of an exaggeration, but it's time for this case to get litigated in South Carolina. That's my view. Because we start off with these horrible things that CAPE is accused of doing, and we just listened to a recitation of evidence to support the allegation. We haven't tried it, so I don't know. It might not be a winnable case. You point out that the court in Texas picked apart that evidence and said, you're slightly off the mark, or you're way off the mark. Maybe that's true, but you know, I don't even know if there's a question in there, but there's just a lot of frustration. And when we talk, I got a question about insurance. I'm asking you about insurance. Wouldn't the receiver be entitled to try to figure out whether CAPE is insured? And all I hear about is all this other technicality stuff. I mean, isn't it true that the receiver is entitled to try to figure out whether CAPE is insured? Somebody, you don't like that receiver, somebody is entitled to ask CAPE, to ask Lloyd's of London, to ask Alliance, is there insurance? And there's not an answer to that question from y'all.
Justice Few.
Whereas the answer is inescapably yes.
If the defendant is subject to personal jurisdiction in the first place, like that, you were trying to find the word, you were saying they're not showing up. They're not showing up because they're not subject to personal jurisdiction. I mean, this is, I don't throw the due process around like a throwaway concept in our Constitution.
If they're not subject to personal jurisdiction, I'd be the first one to congratulate them for the courage to not show up. But there has been significant evidence summarized to us that they are subject to personal jurisdiction. That needs to be litigated. It's time to stop all these appeals. It's time to get down there and let it be litigated.
Your Honor.
I'm done. There aren't, Chief, I'm sorry, there were no questions in there, so there's no need for you to answer.
But
You can respond if you'd like, sir.
yes, sir. Look, I share your frustration. If you have questions about any appeal that we have filed, I'm glad to discuss it. Every single thing that I've filed has cited a statute or a case or both in support of our position. Sometimes we win, sometimes we lose. That's why there's a V right between our names. But every filing that I've made has been eminently defensible, and I'm glad to answer those if that's the rub here. But
I don't mean to accuse you of acting improperly. I'm simply pointing out that there's an issue here that needs to be tried.
and it has been tried. That's Adams, and Adams answers the personal jurisdiction question as well.
So
You were very-
wait, hold on.
Yes, sir.
You're saying that the Adams decision from the United Kingdom voids the Texas federal court judgment that found personal jurisdiction over these defendants? Is that your argument?
In the default judgment, yes.
So English court can void United States federal court judgment.
Well, the issue,
That's your position?
it is in that instance because in Texas, that point wasn't litigated. It was a default judgment. Well, that's, Your Honor, that's,
Okay, I get
that is how the law works in that regard.
But you can't have a default judgment unless there's personal jurisdiction found by the court. Isn't that what the Texas court found?
I don't know what the Texas court found, but
Okay.
I know that the first stop in opposing the enforcement of a foreign judgment, whether it's North Carolina to South Carolina or Texas to the United Kingdom, the first stop in that enforcement effort is to say, well, did they even have jurisdiction to enter that order? And Adams goes in great detail about the absence of presence by CAPE in the United States. And this is, but we didn't mention Adams in our first several filings because you don't even have to get to Adams to appreciate our personal jurisdiction argument. When I tell you CIHL is they're not a defendant in this case, it's because they're not a defendant in this case. You can't have personal jurisdiction of a company if they're not even named as a defendant. CIHL was never served with anything in this case. The Park case is where the notion of like, well, was it a summons? Was it a complaint? That's all in Park. In the Tibbs case, which is where this appeal comes out of and where the CIHL concept in receivership comes out of, They weren't served with anything. There's no proof of service anywhere in the public index. And in hearings before Justice Toll, Ms. McVeigh has said, well, we just served the receiver as Cape. Like that, the folks in England never got one shred of paper about this case, okay? That's critical. That's a jurisdictional due process defect. It's not a technicality. It's the Constitution. Due process doesn't yield to the convenience of plaintiffs, okay? So I want to end where I started. And thank you, Your Honors. We've gone way over time, and I really appreciate it. This is a very important case. But I'll end where I started. Unrebuttable. CIHL is not a party to the Tibbs case. CIHL has not been served with anything in the Tibbs case. And the Tibbs case is where this appeal comes from. There's an order from Justice Toll in October that says, hey, I'm changing my appointment from Cape PLC to CIHL. She can't do that. CIHL is not a party to this case. And number three, CIHL has no property that's in the state of South Carolina. It's unrebuttable. Thank you for your time.
Thank you so much. 2 minutes, Mr. Raw.
Thank you, Your Honors. May it please the court. I'd like to go back to some of what Ms. McVeigh pointed out and some of the questions that were asked to her. And I, Justice Few, I share your frustration that something should be happening with, this case between the plaintiff and Cape. However, I don't represent Cape. I represent a company that was formed in 2022 that has no relation to this whatsoever. This being sued by a receiver that was appointed in a case other than the one where I'm being sued in. And so I think it's important to look back at the Park case where, and Ms. McVeigh represents the Park plaintiffs and the Tibbs plaintiffs. And the question that was asked is, why didn't you just put them into default? If you claim that Cape was served and they were in default, then put them in default. There's not a good answer to that. But what the receivership statutes do say, and this is 1565-10-1, is that if the company is in default, a prejudgment receiver is not appropriate. There are plenty of cases that say a receiver is never appropriate if there is another remedy at law. And so, while maybe they could go and get a default judgment and then perhaps appoint a post-judgment receiver that may have more authority than a pre-judgment receiver, there's a reason they don't want to do that. If you get a default judgment, then all of a sudden you then have a defined amount of money. Let's call it $1 million. That would be the goal of the receiver, to go and collect $1 million. By the way, if we believe the farce, the Park plaintiffs are the one who asked for the appointment of a receiver. The appointment of the receiver, is only their interest to protect the possible judgment for their case. But that's not what's happening here. The receiver is not being asked to just make sure you have money to protect Park. The receiver is being asked to go and basically do supplemental proceedings in advance, not to protect the Park plaintiff, but to protect all possible plaintiffs that plaintiffs' counsel may bring in the future. This is the purpose of what's going on here, and you can't separate. I kind of say, stay in your lane. The plaintiff, makes a motion to appoint a receiver. It has to come up with the evidence of moral fraud. It has to say, what asset is at issue identified. The receiver, if he is appointed, then has to follow what the order says. It's not up to the receiver to say, now I'd like to go and start protecting some other people. Oh, by the way, I'd like to act in this case now, even though my only role as a prejudgment receiver is to hold and preserve the assets pending judgment in the Park case. So the whole idea of a prejudgment receiver, which is what was appointed under Title 15, it disregards all of the due process protections in the statute. But there's never been a prejudgment receiver that has been told to go maximize a fund for future use to people who didn't ask for your appointment. And it's clear if you look at
Mr.
Section
Mr.
1565.
Ashmore might disagree with that.
I apologize. 1565-90 actually puts the responsibility of the actions being taken by the receiver who's appointed upon their motion on that person. So if the receiver here who's acting well beyond the Park case is deemed to have done something wrong, all that liability goes back on to Parks for making the motion. And I'll just end with, if you look at the complaints in Park and in Tibbs, KPLC and CIHL were both identified as current existing companies. They were both named individually. In the Tibbs case, same plaintiff's counsel, only KPLC as a current active company was named in the complaint. CIHL never was, which is why in the Tibbs case, the plaintiffs have not made a motion to appoint a prejudgment receiver to hold or protect assets for Tibbs. It's because they can't make the motion. They haven't sued or alleged any wrongdoing against CIHL. They have no basis to make a motion to put assets of CIHL in the hands of the receiver because they didn't sue him in the first place.
Thank you, sir.
Thank you very much.
Appreciate it. Thank you for your patience this morning. It's been a long hearing. We've studied the briefs. We'll continue to study and take the matter under advisement. Thank you so much. We're adjourned.